Hello everyone, welcome to NeenvIAS. We have been discussing the polity previous year questions and today's theme is the president. This is a question from 2023. Consider the following statements. If the election of President of India is declared void by the Supreme Court, all acts done by him or her in the performance of duties of his or her office of President before the date of decision becomes invalid. So basically this point is trying to tell us if the election of President is declared void by the Supreme Court. So whatever the President has done during the period before the election was declared void, all those acts become invalid. Statement 2. Elections for the post of President can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. So point 2 is saying that, say for example, in the state of Andhra Pradesh, the assembly is dissolved during the time the elections for the president is happening. So at that point of time, the presidential election will be postponed because a particular state assembly is dissolved. So this statement is saying whether that is correct or wrong. And statement number 3. When a bill is presented to the president, the constitution prescribes a time limits within which he or she has to declare his or her assent. So this point says that when a bill is given to the president, for the president to give his assent, there is a time limit which is prescribed in the constitution. So this is the key point. Now, how many of the above statements are correct? Before we discuss the question, let us go into the static part and recall. Now, what does Article 71 in the Constitution talk about? The bare act talks about the matters relating to connected with the election of the president or the vice president. So the bare act says that all the doubts and disputes arising out of the election of the president or the vice president, they shall be inquired and decided by the Supreme Court, whose decision shall be final. So note, here it is not the election commission, but it is the Supreme Court which is the final authority to decide on the disputes of elections of either the president or the vice president. So in such a case, if the election is declared void, and in that cases, whatever are the official acts done by the president or the vice president, they do not become invalidated just because the election got declared as void. So whatever are the official acts done by such a president or vice president, they will be valid. So this is the point which was in question. And subject to the provisions of the constitution, the parliament may by law regulate how the elections take place. And the clause 4 says, the election of president or vice president shall not be called in question on the ground of existence of vacancy for whatsoever reason among the members of the electoral college electing him. So if you recall who are the members in the electoral college of the president, it will be all the elected members of the Lok Sabha, elected members of the Rajya Sabha, and all the elected members of the state legislative assemblies. And the electoral college does not include any nominated members. So in such a scenario, here we were discussing about the state of Andhra Pradesh. So if the state of Andhra Pradesh is dissolved and the MLAs are dissolved for whatever reason it is, just because that has happened, we won't postpone the elections of the president, or we won't declare the elections of the president invalid. It in no way affects the election of the president. It's just that the MLAs who are disqualified, they become disqualified from voting for the president and they do not remain part of the electoral college. So their dissolution in no way affects the presidential elections. So here we are very clearly sure about this statement, statement number 1, which says that all the acts become invalid, so which is clearly wrong. And the statement 3, which says that, statement 2, which says that the elections can be postponed just because the legislative assemblies have been dissolved. So that is also wrong. Both the statements could be answered from Article 71. Now for the third statement, when the bill is sent to the president for his assent, after the bill being passed in the Lok Sabha and the Rajya Sabha, and the bill is sent to the president for his assent, he has 3 alternatives. Either he can give assent to the bill, that is, he agrees with the bill and it becomes an act, or he can withhold his assent, or in some cases for the ordinary bills, he can send the bill for reconsideration, and when it comes back with or without amendments, the president has to give his assent. This is in case of ordinary bills. It will be slightly different for the money bills and the constitutional amendment bills. And it is crucial to note, in the constitution, there is no time limit that has been fixed for which the president to give his or her assent. So when the bill is sent to the president, or the president wants to withhold the bill, or if he wants to reconsideration, there is no fixed time limit within which the president has to act. So now let us come back to our question. So statement number 3, which says that when the bill is presented to the president, the constitution prescribes the time limits. So which is clearly wrong, because the constitution does not prescribe any time limit. Now the question is asking us, how many of the above statements are correct? So none of the statements are correct. So our answer would be D for this question. So answer is D.